We've discussed already the difference between informal and formal rulemaking, but two of the things that both of them have in common, of course, are the requirements that there be notice and that there be an opportunity to comment. So let's talk a little further about both of those elements, and first, let's talk about the requirement of notice. Why do we get public input? That's a really good question. Because as public managers, of course, as we've talked about before, you provide expertise. Presumably, you are in your jobs because you understand these issues. You've been trained professionally. You've gotten, or you're about to get, your MPA degree, and you provide a level of professionalism and adherence to facts and evidence that the public simply doesn't. The public is more like Homer Simpson, making their decisions based on emotion and half knowledge. So why on earth then do we care about what the public has to say on complex issues, say for example like regulating the nuclear industry? Well, notice has definite benefits, and some of these are symbolic and some are not, but one of them is definitely the issue of legitimacy. We live in a democratic nation, and fundamental notions of due process, and not just due process, but democracy and democratic theory require that the public have an opportunity to know what's happening before it happens and to weigh in. And although, yes, of course, many comments may be uninformed, in fact, notice can result in improved rulemaking. As we mentioned earlier, there actually aren't that many comments on most rules, and some of the people that weigh in do indeed have specialized knowledge or bring points to bear that ultimately make it into the final rule and improve the rule that was being considered. In addition, notice can be useful because, of course, an agency, their responsibility doesn't end with issuing the rule. Of course, they then have to enforce that rule. And notice can help them anticipate public reaction to what it might happen once that rule's implemented. What might some of the problems be, how vociferous the opposition might be. And so notice helps the agency plan in this way. In addition, notice is important because, as we've mentioned, almost every action or most actions will probably be reviewed in court, and notice facilitates judicial review by building a factual record that the court can examine. So, notice, what is required? Well, the Attorney General of the United States has a manual that provides internal guidance to the Department of Justice, and a chunk of this manual it's the Attorney General's interpretation of the Administrative Procedures Act. And according to the Attorney General's manual, notice must be sufficiently informative to ensure an opportunity to participate intelligently in the rulemaking process. In other words, it's not enough for an agency to simply give notice to say, hey, we're going to change a rule, but the notice has to be informative enough to allow people to, again, participate intelligently in the process, to know enough about it, to be able to gather evidence and to analyze the proposal in a rational way. D.C. Circuit Court of Appeals has said that notice must also be clear and to the point. A lot of times lawyers like to bury things in complex legal language, and too much legal jargon may violate fundamental requirements of fairness. So let's talk about a couple of examples of what might constitute inadequate notice. One happened in the case of MCI versus FCC back in 1995, and in this particular case, the court found that inadequate notice was given because the relevant issue that the agency was considering changing was only listed in a footnote, And that was in the background section of the notice, and it was in a different, it was discussing a different issue. The footnote was actually sort of just kind of stuck in there. So you had a footnote that was weirdly appended to a sentence that was in an inappropriate section, and the court found that it was there, but it was far too difficult to find, and therefore it was inadequate. In small refiner lead phase down task force v. EPA, and of course, as I've said, I'll never ask you to tell me the name of a case. The EPA said that they were going to they were considering changing the definition of small refineries. The court found that that was just too vague. Small refineries didn't specify the range of alternatives that the EPA was considering, and as a result, individuals who might want to comment had really no idea what the proposal was that they were planning to comment on. So as you can tell, in one case, you simply had something that was very vague. In another, the notice was specific, but it was hidden. So again, it needs to be plain, needs to be easy to find. So one interesting thing that happens, of course, is what happens when a rule changes. The agency normally, of course, they propose a rule, there is notice, there's an opportunity for comment, and the agency is supposed to consider those comments, and oftentimes the agency will change a rule in response to comments that it has received. If it receives a good comment, there's no reason why it shouldn't change the rule. But the question then becomes, what happens when a rule changes? Does the agency have to go through the notice and comment procedure again? And you can see how this might be kind of annoying, because if you have a rule, it goes through notice and comment, it gets revised, it goes through notice and comment again, then you change it again as a result of new comments. The process could go on and on and on. So what the courts have said is that an agency does not need to go through the notice and comment process again if the change in the rule is a, quote, logical outgrowth of the agency's proposal. Now, that sounds good, but of course, the question is, what does the phrase logical outgrowth mean? That, of course, is extremely ambiguous, it's extremely subjective, and that's just going to be up for a judge to decide. It makes sense. If it's a logical outgrowth and people could have anticipated it, then why go through notice and comment again? If it's something nobody could have anticipated, then perhaps you should. But the question is, where do you draw the line between the two? Well, the courts have tried to define this. They say, well, what is a logical outgrowth? That's a change that was reasonably foreseeable. But of course, as you can tell, this explanation is no more specific than the original phrase. But let me give you an example. I like this case. It's pretty easy to understand, and it's a good illustration of this point. This is the Chocolate Manufacturers Association versus Block. And this was not decided by the Supreme Court. It was decided by the Fourth Circuit Court of Appeals in 1984. And this one involved, as you can see here, Nestea and Nesquik chocolate and other chocolate milk additives. In Chocolate Manufacturers Association v. Block, the USDA, U.S. Department of Agriculture, had regulations that permitted use of flavored milk in federal food programs. So say the federal school lunch program, the USDA allowed chocolate milk and other flavored milks in these federal food programs. Well, there was a change to the USDA's Enabling Act in expanding its charter, expanding its charge, and as a result, the USDA held a rulemaking procedure. They were proposing a rule. Now, in this rule that they noticed, they didn't say that they were considering changing the flavored milk provision. This wasn't something that was in the original rule, but several of the commentators wrote in and said, hey, flavored milk, it's terrible, it's just got a bunch of extra sugar, kids shouldn't be able to drink it. And so several commentators suggested ending the use of flavored milk. And therefore, when the rule was finally issued, it ended the use of flavored milk, even though the original notice never said anything about it. So, of course, the Chocolate Manufacturers Association sued, claiming that the rule was not a logical outgrowth of the original rule, and that therefore it needed to go through an entirely new notice and comment period. And again, it'd be interesting to think what you yourself might think about this. Would you think that this would need to go through a new notice or comment, or is this a logical outgrowth of the originally proposed rule? Well, in this case, the court ruled that the notice was not sufficient and that the revised rule was not a logical outgrowth of the original rule. The USDA had never suggested that removing flavored milk was an option, and so there was no way. The Chocolate Manufacturers Association probably would have weighed in. They probably would have made an argument against that if they had known. And so they basically lost their opportunity, but that was only because they'd never been sufficiently notified of their opportunity. The court said the total effect could have led interested persons only to conclude that a change in flavored milk would not be considered. So again, a good, I think, easy to understand example of the kind of notice that's required. So one question is, what about the disclosure of studies?